We're very, very excited to have Tina Piper here from Creative Commons Canada. She is a professor at McGill's Faculty of Law and a member of the Centre for Intellectual Property Policy, specializing in patent and copyright law. And Tina comes to Creative Commons Canada after having been at Creative Commons England and Wales while completing her PhD at Oxford as a Canadian Rhodes Scholar. Before joining McGill, Tina clerked for the Chief Justice of the Supreme Court. So that's my mentions. Thanks very much for coming, and please welcome Tina Piper.
Thanks for having me. I'll probably just stay seated and keep it brown bag lunch. Informality. I just wanted to, first of all, ask you where you're coming from on this question as a group, just so I can make sure that if there's stuff that you want me to bring out about Creative Commons, or if there are questions we had right off the bat, that I could try and work the presentation around that. I have a sort of everything you wanted to know about copyright and Creative Commons and how it all fits together in the world as we know it kind of presentation. And if that interests you, then I'll just go ahead with that, and I'll leave time for a good discussion so we can address the questions that come up. So start off basically by looking at copyright first of all, and then some history, because I think the historical. I'm going to stand. My voice projects a lot better that way. Then I'm going to be looking at some history of copyright law, because I think where we are today in terms of copyright and Creative Commons and how it fits into the Canadian picture really reflects the history of where it's been. And you can get a sense that the changes that are happening right now in terms of copyright aren't actually unusual or reflect something that existed in the past. I'm then going to be talking about some present concerns, and finally Creative Commons, which I like to call the solution. I don't think it is the solution. I think it's a solution, one of several things, one of many things, and really creativity and legal ingenuity are the only boundaries to coming up with more creative things that we can do to affect the goals that we're trying to achieve through Creative Commons. So in terms of intellectual property, I wanted to start right from the basics. Most lawyers don't even know this kind of stuff, so if you do, you're already at least in second year of law school. The difference between intellectual property and other kinds of property in law is that, for example, if I had this, I put a pen there, but if I had if I have a bottle, for example, it's finite. It's governed by things like property law. You steal it from me, I can prosecute you, I own it, I can do all sorts of things with it, I can hit you over the head with it. There are all sorts of things I can do with the bottle. Now, in terms of intangibles, something like a film counts as an intangible, and the problem with the intangible in law is that there isn't really a thing that can be governed. So it's not as easy as the bottle. You can't necessarily hold it. You can hold the container that contains whatever that intellectual property is. So you can hold a DVD, for example, that holds a movie. But the actual property, the actual thing that's being governed is the intangible, is the thing that you can't, you can't hold. And the real problem that intangibles cause for the law is that you can reproduce it infinitely at almost no cost. So if I want to produce lots of bottles, I have to set up a bottling plant. If I want to reproduce lots of movies, I just have to hit copy on my computer lots of times. And it also means that, for example, when I drink out of this bottle, nobody else is drinking out of it. But if I'm watching a movie and I've given you a copy of that movie, you can watch it at the same time as me, and it doesn't detract at all from my use of it. So I don't get less apple juice because you're drinking from my bottle. That's the sort of analogy that happens. So it creates all sorts of real problems for the law, because nobody really knows what to do with this kind of property that doesn't look like any kind of property that we have, that we regulate in law. So intellectual property are the rules that balance the rights of creators and the rights of users. And so they're the norms that set up in a sense, the rules of the game for how to deal with things that have these characteristics that don't map onto regular law easily. So the means, the mechanism by which this happens is through granting copyright. So copyright is an artificial right in the sense that it's created by law, it's created by the Copyright Act here in Canada, and the creator is given the right to be the only person who can reproduce that particular work, and the only person who can profit from that reproduction or from that dissemination of the particular good, whatever that may be. And the point of copyright law is to create a thing called artificial scarcity. So it's to create scarcity in a good that wouldn't otherwise be scarce because of the reasons I told you about before. So you can copy it as much as you want. Many people can use it at the same time. It's not easy to market something that doesn't have any sort of artificial scarcity because it's very hard to create demand. And the important thing to remember about copyright is that it's created for a limited time. So it's bounded. It's not meant to be a perpetual right. It's not meant to last forever. It's meant to end at some stage. And that users are given a certain number of circumscribed rights to use a copyrighted work. They're not totally barred from using a particular copyrighted work, but they're given a set of rights that are limited by the statute law as defined. And then when copyright expires, the work is set to move into the public domain. And so the big tension that I'm going to be drawing out here is that the public domain is becoming illusory, is the argument. Copyright reforms and the progressive statutory reforms that are happening tend to expand the scope of copyright, and there isn't really a countervailing force that's trying to limit the expansion of copyright. And so this idea of the public domain often remains a bit illusory. Right now we're working at Creative Commons on developing a public domain wiki, and so the idea behind the public domain wiki is to actually create a database or a wiki which are different, but it's with Wikimedia, so that's where the wiki, I don't think it's a true wiki exactly, but I think of it more as a true database, but it's to create a database of public domain works, because the real problem is nobody knows what works are in the public domain. And so you have this public domain right, you have these works that are in the public domain, but if you don't actually know what's in there, it's not really useful to have the public domain. And so part of that goal is to say what's in there. So for example, Lucy Maud Montgomery's books and poems that have entered the public domain, these sorts of things. So we get a bit more of a vibrant public domain growing. And the whole idea behind intellectual property law more generally is this idea that you want to incentivize people to create more works. That's the governing paradigm behind intellectual property law. We wouldn't have intellectual property law unless we wanted people to create more. And so the whole idea is that this system of granting these sort of bargaining tokens called copyright law or copyrights over certain works encourages people to be more creative. Now you can decide whether you believe that or not. The implication of that is that then culture and society benefit, and we're all sort of raised above because we have access to more cultural goods. But that story of late, people have been arguing, is incoherent. That this idea that granting a copyright directly incentivizes a certain kind of behavior isn't necessarily proven. It's speculative. It's based on one vision of behavior. So it's based on the idea that the best way to incentivize behavior is to reward someone through this type of right. But there might be other reasons why people create and other types of incentives that would lead them to create more and more of the kind of things that we're interested in. So you might give them a reputational token, for example, instead of a copyright token, so a property right over whatever they created. You might give them reputational tokens so that within a certain group their reputation is enhanced. I mean, that's a really mechanistic way of seeing it. A lot of people create just because within their group, if they make something nice and people like it, then their status within the group is raised and they have access to more benefits within that group. So that's one of the ideas. People create just for pure reasons of enjoyment. People create because they need to. There are a whole bunch of reasons. So what Creative Commons and other new sort of countercultural copyright movements are trying to do is capitalize on these sort of other incentives to behavior that lead to creativity. Because I think we all agree, sort of as a final stage, that we want lots of creativity and we want people using other people's works a lot, and that's a good thing. But how do we get there? And how do we make sure that people who create get compensated for that in the way that they'd like to be compensated? There's also all sorts of other problems with the traditional copyright story, and over time the system has become much more rigid. And so there are concerns with monopoly, over monopolizing certain kinds of content. There's this myth that artists directly profit in most cases. It's actually people to whom they've assigned their copyrights. This is really common in the music industry, but also often in the publishing industry. And so you get these situations where this idea of incentivizing an artist's behavior falls apart, because how can you incentivize someone's behavior if they're not actually benefiting from the right? It's an equation that falls apart. And there's other concerns. Concerns about legislative lobbying and special interests. There's been a certain ossification of the system, I think is the word, a certain polarization, a sense that the system isn't as flexible as it once was or could be, and it's not being used. So the whole idea behind Creative Commons is that we have standard copyright, which says all rights are reserved. So that's basically the idea that under copyright you're given a bundle. This is the traditional law term. The bundle of rights, you're given a bundle of rights, and so within the bundle you're allowed to copy, transfer, assign, reproduce, do any number of activities with a particular creative work. And the whole idea behind Creative Commons is that is this idea of some rights reserved. So you can give away certain of those rights in that bundle. You can decide that you're not going to enforce some of those rights. So the basic idea behind Creative Commons is that you can decide that other people can reproduce your work for commercial or non-commercial purposes, and you're not going to try and control that. So in effect, you've taken that stick out of your bundle, that I'm the only person allowed to reproduce a certain work. You've taken that stick out of your bundle, and you're saying, you know, I'm giving you, through a license, I'm giving you the right to do that without asking me for permission. The public domain is when you've reserved no rights, so you have no copyright claims over a particular work. You're not claiming the right to reproduce a work or to be the only person who can assign it, and all these other features. So the question, and this is where we get into the history. So I've given you the basic sort of nuts and bolts. So that was the sort of the heavy law bit, and now I get sort of more into the this is the more sort of visual bit. The question is why is the Creative Commons important? Why do we care? Is really the question. And one of the basic ideas around Creative Commons and its genesis. So I wanted to give you a bit of a sense of the history and the context from which it's developed and the history on which it draws, which led to its development. Is this idea that creativity builds on the past, and this is the idea behind the PD Wiki, the Public Domain Wiki project I was telling you about as well. Accessing this pool of creativity that's available to us all, if we can just identify it, is really valuable. I mean, you think about it when you go on the internet, you go to someone's site and they've posted something, you don't actually know what rights privileges you have with respect to, like, they have a photo on their website, for example, you want to use it as your background, or you want to use it in your website, or wherever. Without knowing what rights attached to that, you have to assume that the full copyright bundle has been retained. And the idea behind Creative Commons is to give you a map, so you can attach a license to that work, and you can say, actually, I'm going to let you copy that, and I'm going to let you do a whole bunch of other things. So it's about creating a space of dialogue between users and creators, and it's about creating a space where people can be much more flexible with what they're using. So the idea that creativity builds on the past is and I've ripped this off from Leigh Lessig, but it's a fun sequence. It's this idea that without the past we wouldn't be able to really create as effectively in the present. And it says, if I have seen further, it is by standing on the shoulders of giants. Said by Sir Isaac Newton in 1676, but in fact he got that from George Herbert, who said something similar, a dwarf on a giant's shoulders sees farther of the two, who got it in fact from Stella Didacus in 1622, that dwarfs on the shoulders of giants see further than the giants themselves, and then could be traced back to 1159, to a much longer quotation, we are like dwarfs, and I'm not going to read the whole thing, but the idea behind creativity building on the past is this idea that not only do we build from the past, but often the things we create get better, or more, things change. I won't make that judgment, but there's this idea that without the past, we might not be quite so creative in the present. So the early history of copyright is that in 1710 in the UK, and so I'm going to be talking about Canada, the UK, and the US. In the UK, because they all fit into a nice picture, we derive most of our legal history from the UK, bits of it from the US. The statute then passed a statute that said copyright's going to be, created this thing called copyright. It's copyright for 14 years. So I introduced this to you only to say that this is something that was created. It was created in 1710, and just as it was created, I think we can feel free to talk about what life would be like if it were different. In the 1740s, the London publishers argued that copyright should be forever. And so they, after some heavy lobbying, and they were characterized as monopolizers in the trade, men who do not labor in an honest profession, learning is indebted. So they were characterized as parasites, effectively. But they lobbied heavily for a perpetual copyright over the works that they earned their money from. And this thing was going to be called common law copyright. And in 1769, they actually won. And so in 1769, copyright did last forever. It never ended. Then in 1774, that decision was reversed. And we have the situation that we have right now. Terms no longer 14 years. But we got back from that stage where copyright was going to be forever to a moment now when it's for a limited term. So that's the sort of the antecedents of this movement, or this copyright term. And in 1790, the US passed its first copyright law. And its term of copyright was 14 years as well. And the person who did more for copyright in the US than anyone else is Walt Disney. He created a film, among other things. He created a character called Steamboat Willie. And Steamboat Willie was effectively Mickey Mouse. But it was based on an earlier production called Steamboat Bill Jr. by Buster, featuring Buster Keaton. The point behind this is that Walt Disney's early creation was actually based on characters that he'd found elsewhere. And in fact, he was characterized by executives at the time as always parodying the feature-length mainstream film. And eventually, as his body of work demonstrates, was quite good at mining cultural narratives, cultural stories, fairy tales, all sorts of tales to create these feature films. And one of his particular favorites was the Brothers Grimm, from whom he derived characters like Snow White. And so the idea behind this is that we went from a vision of the commons existing with a small domain for copyright that lasted for 14 years to us, after some significant lobbying, a term of copyright that lasted for 42 years in 1831, to 56 years in 1909, to 59 years, and so on. And it increased to the point where in the US today, for some works, you can have copyright for 95 years. And so we're getting closer and closer to this concept of perpetual copyright that was explicitly rejected in the 1700s in the UK. We're getting closer to it. And the question is, what's that doing for us? How is that helping? How is that helping us create? How do we structure our lives around that? And in the U.S., the Sonny Bono Copyright Term Extension Act was responsible for the most recent extension of copyright term. But interestingly enough, was also the impetus behind the creation of Creative Commons. So it was Sonny Bono. It was called the Mickey Mouse Protection Act, which alludes to the fact that every time Mickey Mouse threatens to come out from copyright protection or from its associated trademark and patent protection, Walt Disney goes and lobbies for copyright term extensions. So there's a direct correlation between this campaign to free Mickey and the movement here. So Canada's situation, and I want to highlight this is that in 1924 we introduced our first copyright law, and copyright term was 14 years in that case, so it started from the standard baseline. At present, the copyright term is 50 years, give or take for different media. So there are exceptions carved out for different objects, photographs, for example. Now, the argument is that copyright is becoming more and more encompassing. As we extend copyright term, that's one aspect of how it's become more encompassing. But also, the scope of what copyright covers, so the cultural products that copyright now covers, has also grown concomitantly with the extension of term. In particular because the law regulates copies. Now, the idea behind this is that before the internet, before sort of digital media really took off, when you're talking about copyright, you're talking about a series of unregulated uses. So there were things you could do with a particular object that copyright didn't even touch. You could read a book, you could give a book, you could sell it, you could sleep on it. There were any number of things that you could do that copyright didn't even touch. The world was your oyster. And so there was this limited domain of things that copyright covered, and then there was this much larger domain of unregulated uses. Now, and just have some examples. The important thing to note here is this fair dealing exception. So this was the idea that within the realm of copyrighted things, there were also, and that's the gray band, and the gray band will follow us throughout this little section. The scope of things that you could say that copyright didn't cover was fair dealing. So fair dealing is, for the purposes of criticism, review, research, you could claim an exception to copyright if you were engaged in any of those activities. So news reporting, for example, is covered by fair dealing, things like that. And so even within the scope of copyrighted works, we have this band of fair dealing which allowed you to do things with copyrighted works without asking permission from the copyright holder. You could quote things as well. So we had a world that was constructed of things, unregulated uses, regulated uses, that were then balanced with a fair dealing exception, and things that were covered by copyright. That was what the world looked like. Then the internet came along, and and it's not just the internet, but also easily reproducible digital media, effectively, and files. And every act became a copy. And that was when things started getting really complicated, because that sphere of unregulated uses became heavily regulated. And so most of what we do now online, and it's almost hard to picture what it's like not living in that world anymore. Almost everything we do now is regulated as a copy. If you receive files, you've copied them. You send files, you copy them. You're not reliant on, you don't give your colleague an article anymore, you send them a copy of it. All these things have now become regulated by copyright. Most of what you do on a daily basis is likely copyright infringement on a very small scale, unless it's covered by some of the fair dealing exceptions. And so that raised a big question, because if we're all violating copyright all the time, then it actually makes it kind of meaningless. It's kind of like a law that doesn't really exist, because if you exist if just existing means that you're violating it, it's very difficult to take it seriously. And so we lost a lot of unregulated uses, but we were left with the fair dealing exceptions in Canada and copyrighted works. So, and that's an interesting situation, because in Canada, our fair dealing exception is quite narrow, and this has been the critique, is that in the U.S. they have this thing called fair use. Fair use in the U.S. provides for real balancing between the rights of the creator and the rights of the user, and so it's hard to. In Canada, we basically have an enumerated list of things you can do, and if you do one of those things on the list, private study, research, criticism, review, newspaper summary, then you might fall within the fair dealing exception. In the U.S., they have a much broader category that just says if you meet any of these criteria, then you may be engaging in a fair use. And those criteria are characterized very broadly, and so it's much more of it's a much broader concept. In Canada, we do have some hope, and I wanted to mention this. After the CCH decision, it was the Law Society of Upper Canada and CCH, the Supreme Court of Canada came up with this thing called users' rights, which is completely new in Canadian law. It's the first time ever articulated. We're not sure that everybody was really, so all the law professors were really excited about users' rights because it promised that there was going to be this broad exception for fair uses of copyrighted works. The reality is that business is pretty much continued as usual. Even though the Supreme Court of Canada has said that we do have this thing called users' rights, it's not a closed list anymore. You don't have to just fall within one of those enumerated uses. You can actually be doing something broad, and as long as it fits in with this general category of users' rights, then maybe it's permitted. And so the idea is that fair dealing has expanded now to something beyond mere exceptions, to an actual category of use. So that's the gray circle here. That's the idea that the fair dealing exception has really expanded. Yeah, it's optimistic. I don't actually know. I've been watching practice in the publishing industry and particularly in the legal publishing industry, and it doesn't seem like they have any. They just decided to ignore CCH and pick up. It's kind of like when I read CCH, I only know the parts that say that fair dealing's now all about users' rights, and when they read the decision, they read all about the parts where the court found that there was copyright infringement. So that's basically the two sides will never communicate. So what we're trying to say, what Creative Commons is trying to do is take us from the situation of 1773 where we had copyright forever to a situation where we can create like in 1790 when the court, Miller and Taylor, said, you know what, copyright isn't perpetual, and there are all these things you can do. And so that's where Creative Commons comes in. Creative Commons tries to expand. So you have your domain of copyrighted works, and a lot. My guess is that some fraction of that copyright pie is actually people who just haven't thought about it, or people who haven't communicated it to you. You've put stuff on your website. You wouldn't mind if your friends shared it. You wouldn't mind if people reused some of your content, provided that they said that you'd created it, and maybe provided that they weren't using it to make lots of money off you, but maybe you'd be happy. And so Creative Commons is just about communicating that and trying to reduce the sphere of copyrighted works where that default presumption of copyright applies, and try to make things more explicit. So we get back to the bundle of rights. The default presumption is all rights preserved, and Creative Commons is basically saying some rights reserved. But how do you do that? And the way you do that is through a thing called a license. And licenses have really grown in importance in recent years. Basically, a license is there are all sorts of licenses. In this case, it's a unilateral agreement between you and the world, saying, giving the world a right to do something that otherwise wouldn't be legal. And so what Creative Commons has done is Creative Commons has gotten rid of the lawyer. So if you wanted to do that normally, you'd have to go to a lawyer and they draft a complex agreement saying that you give the world the right to do these sorts of things. Creative Commons, really simple concept, came up with a standardized set of licenses that allows you to do that yourself. That's all it is. Creative Commons doesn't enforce your rights, doesn't go to court for you. It just gives you a template of a researched, enforceable agreement that you can give to anyone in the world. And I'd like to think of it as a public legal education project, because what it does at the end is really just gets you thinking about what copyright is. And it gets you thinking about what you want to use your copyright for. It's your right. So just think about how you want to use it. And that's all the Creative Commons does. And I call that the propulsive approach to creativity. It's the idea that you just think about, why are you being creative? What would incentivize you to create more? If it's peer recognition, then disseminate. Disseminate your works. Use a license. Anyways, these are handy little graphics I've downloaded from the Creative Commons site. I didn't come up with them myself. But Creative Commons has a series of symbols that you might recognize. This is the public domain symbol. This is the share-alike symbol. So I'll go through these actually on the proper diagram here. So attribution means that you want someone to recognize, you want to be recognized as the author of your work. So that, it's funny, when we started with Creative Commons, the idea, we thought that people might not choose that option. They actually choose that option 98% of the time. So that seems to be one of the most important things. People just want to be seen as the author. The share alike provision means that if you attach a Creative Commons license to your work and it's incorporated in a later work, then that person, the author of the later work, also has to attach a license with the same provisions to their work. So that's the viral copyleft side of things. That's what people don't like about Creative Commons licenses to some extent, is this idea that you're forcing people downstream to subscribe to a Creative Commons license. I like to think of it, and I accept that complaint, but I also think it's an important part of building the community and building that community of trust and document, I guess in a sense, a body of creative works. No derivatives means you don't want people to create follow-on works incorporating your work. So you want them to be able to access and do any number of things, but you don't want them transforming your work. So those are the main aspects of the Creative Commons license. Those are the sticks in the bundle that you can pick and choose. So I'll just quickly go through an example. This is just an example to help you understand how it works. So we have Anita, who wrote a song. She wants people to sample and distribute her song, but she wants to be protected, so she picks a license off the Creative Commons site. So you can pick any number of options. Do you want your work to be modified? Do you want people to use it for commercial purposes? And then you get 3 types of license. You get a Commons deed, a legal code, and a digital code. The Commons deed is a plain English version of the license. The legal code is all the veins underneath. And the digital code is an idea that came about from the idea, and you can see it on Flickr now to some extent. I don't know if you use Flickr. So Flickr uses a lot of Creative Commons licenses, and the idea is that the computer actually reads the code. It reads what you've said people can do with your work, and so sometimes you'll notice if a picture on Flickr doesn't have a Creative Commons license, then you can't copy it. But if it has a Creative Commons license and somebody has authorized the right to reproduce and redistribute, then you can copy those pictures. So that's one of the ways that the digital code works, without you even knowing, to, in a sense, act as digital rights management, I guess, of your work. So she downloads a Creative Commons license with the terms that specifies exactly what she wants people to be able to do with her song. And she, this is the idealized, eventually someone, search engines will be able to tell you. You won't even have to think. You won't have to read the license. You won't even have to know. It will just be done for you. Ignacio wants to use her song in his film. He finds her song, and he reads the Creative Commons license, and he sees what the Creative Commons license says, and he basically says, because she specified that she wants to be seen as the author, that she wants it to be non-commercial, and she wants it to be share alike. He says, I know I can use this song as long as I credit her, and as long as I don't make money from this film I'm making, and as long as if I create a film, then I license it to the exact same terms as her song. So that's basically the idea behind this. So he makes a film with her song, and he credits her, and it's just for his class, so it's non-commercial, and he has licensed it to the same Creative Commons terms. So that's basically what Creative Commons does. I mean, we like to think of it as an easy collaboration tool, or a way of breaking down barriers to communication between people who wouldn't meet and don't know each other, but who might have common interests or have synergies in terms of the kind of works that they're involved with. Now you can probably all see, that's the end of the official slideshow. I mean, you can probably see some of the limitations of Creative Commons as well, right? What do you do with commercial works? A lot of people actually don't mind if you use Creative Commons for commercial works. So WikiTravel, one of the most successful wikis online right now in terms of dissemination and user input, they actually didn't put in a prohibition. They licensed everything to Creative Commons, and they said, we don't mind if you use it for commercial purposes. And so Lonely Planet and Photos and all the big commercial guidebooks started picking out bits of WikiTravel. And they were on the plane one day looking through like En route, and they saw bits of WikiTravel like excerpted in En route, like totally without credit, without attribution, and that was the only problem. So they went back to En route and said, we want you to attribute it to us. We don't actually care if you use it. That's part of our license terms. But we want to be credited because when it shows up in your magazine, then it helps us and it drives traffic to our site. So anyways, that's Creative Commons. And I welcome any questions.
Thanks. We've been playing around with using Flickr and Creative Commons and sort of built into that to do that legal education program, sort of stealthy legal education program. Piece that I have some issues with are the ones that you just spoke about. Are there guidelines to talk about how you attribute? So say, for example, and the story that I always use is I'll give a PowerPoint presentation and I'll say, I just got this picture off the net, but I feel okay with it. I'm never quite sure how to attribute at the end or where do you stick it.
Yeah, I mean, the general idea behind attribution is that you'd attribute in the way that the person made their authorship known to you. So you write, if somebody's written a book, and they say it's by Tina Piper, then you put by Tina Piper in your. But it's a great question and a subject of huge ambiguity. If you want to be 100, and again, it's a gray area. Copyright's it's not criminal law. The state's not going to come after you. There's no independent prosecutors looking, except in the U.S., looking for copyright infringement sort of on their own dollars. So if you don't pursue someone, it's unlikely you're ever going to get caught. It's an area of evolving norms. If you want to be 100% safe, put in a by X, Y, Z kind of probably saying I pulled this off the internet. That's not adequate. But I'm also saying to you, nobody's ever likely going to come after you for it. And if they did, you'd probably fall under one of the fair dealing exceptions. I mean, for research review.
I'm assuming that the use of the material is dependent on where it's copyrighted. So if you're using an American source, then fair use applies, or not?
Yeah, an American source used in Canada would be subject to Canadian law. So that's the international treaty provisions that basically make international copyrights enforceable in a domestic jurisdiction under the terms of the domestic law.
Except if the license, if you're negotiating a license and the license stipulates.
Yes, unless the license stipulates that they'll be subject to the jurisdiction of another country. So again, it's back to default presumptions that you can always change through agreement or private ordering, as they call it. So, thanks.
Yeah, and I don't know if this is a valid question. In terms of trying to prevent plagiarism, we use a site in the U.S. called Turnitin.
Yeah.
And my thought went along the line, what if we're getting students to put something on Turnitin and somebody's, a professor or someone's reading their work and say, wow, that's really neat. That makes a good child's book or a really good story. Does that sort of thing, the fact that it's put into a site like that, prevent them later on copywriting something? Because in a sense it becomes part of a area that other people can view?
Yeah, Turnitin.com is an interesting example. I mean, copyright's automatic. So the second the student writes that paper, they have. My guess is that, and I haven't looked, so I can't speak to the specific arrangement. My guess is that Turnitin probably requires the student to assign their copyright to Turnitin.
I don't know. I should actually go and look at that, but it does or not. Yeah.
It's the faculty members who upload to see if anything else has already been on the site.
Okay.
So I don't think the student's involved at all.
Yeah, the student is, because I get this. I ask the students to upload it themselves.
So do you?
Otherwise, you could spend half a week uploading all the assignments from a class.
Because I know the claim was brought at McGill that it was a copyright. It was a violation of the student's copyright. The professors were uploading it, and I think that's a fairly clear case of a violation of the student's copyright. I mean, that's a reproduction. You don't have the student's permission for it. So, but I think the compromise of McGill, if I recall correctly, was to just get the students to consent to that. And once you have someone's consent, you can pretty much do anything.
Well, the other good thing about Turnitin is when the students turn it up, they turn it in. They get a report back because it can be set up that way, so that they can then take care of anything that might be copied. because it allows them to, you can set it up so they can do multiple uploads in there so that you don't have to worry about all this copying, which would happen if they turned it in to you and then you uploaded it, and then they've never had a chance to really deal with it. But just as you were doing your presentation, that thought came to my mind, are we violating certain rights of the students by asking them to do this?
Yeah, I mean, I think you probably are on some level, but but the question is whether the students, I mean, again, it's copyright, so whether the students complain is really going to decide whether you have to do anything about it. And I know there have been rumblings at McGill about it. It's a gray area. Yeah.
Two questions. Sorry, Zach. First of all, so if a work is in the public domain in the United States, but the creator is known, although it actually doesn't matter, it's actually subject to Canadian copyright laws if we want to use it in Canada. And so it's actually, we're not allowed to use public domain works from the United States.
Well, you would be. Wait.
It's a public domain work in the United States.
Yeah.
But there's a creator, and that person created the thing. I'm specifically thinking of any employee of the U.S. government. They take photographs. They, when they take a photograph of the U.S. government, it releases it to public domain. But does Canadian copyright law apply so that the creator of the photograph or the U.S. government owns the copyright, and that it's not public domain in Canada?
I see what you're saying, because it was created because technically the assignment provisions aren't Canadian assignment provisions, they're American. My understanding is that the treaty provisions that provide for this domestic treatment provide for the enforcement of the right as it exists. And so if there's no copyright on the work, then that's the law that gets transmitted. It's not that there was a creator and that creator created a work that would be copyrighted in any other jurisdiction. For example, you create in Canada, you get Canadian copyright, and that copyright is like an exchange. That copyright is a good token to spend anywhere else. But if you don't even get copyright in your home jurisdiction, you don't have a token to spend anywhere else. So that's basically the way it works.
My other question is, if I have a 800 by 600 pixel photograph and our license is under Creative Commons, under some rights reserved, do I have to give up rights to the original version of the file that may be 2,000 by 1,000 pixels?
Why would you think that you'd give up rights to the original file?
Well, because say I make two versions of it available online, an 800 by 600 for public use, and a 2,000 by 1,000 version, which I want to retain all my rights. Those are those different copies, or are they the same creative work?
That's a really interesting question. I mean, copyright law spends a lot of time trying to decide questions like that, because it's unclear whether a change in format or a change in medium. If you hear these questions all the time. For example, if you have the classic case, Lego. You have a picture of Lego. You have an illustration of what a Lego block should look like, and then you have the actual Lego block. Are they sufficiently similar that a copyright violation, that using a Lego piece, or manufacturing a Lego piece, would violate the copyright in the diagrams? Courts have held some jurisdictions no, some jurisdictions yes. And that's a pretty clear. I mean, I think the picture of a Lego is really different. Like a design drawing of a Lego is very different from an actual Lego piece, but that's not necessarily been found to be the case. So I would say, sort of my best guess on the answer to your question would be that if you had a very persuasive argument that the much more densely pixelated image was of a higher quality and actually conveyed a different image and it was a different format, that you could run with that argument. But
it's an argument.
It's an argument. It's not a decision. It's not. There's no hard answer to that.
There's a big controversy in the open education resources community, people like the MIT OpenCourseWare Initiative, stuff like that, on the non-commercial stipulation of the Creative Commons license. In the past, it seemed to be understood that when you put the non-commercial license, you're essentially restricting the ability of, say, a proprietary publisher or a for-profit entity of some kind coming, taking the materials, incorporating it, and selling it. But there seems to be a point of view emerging now That, for example, if you had a course pack of materials with the non-commercial license, that might actually preclude someone taking a course pack to Kinko's and having it printed at Kinko's, since Kinko's would be making a little bit of money on the deal. So a lot of people are saying if you really want to emphasize reuse, to actually not use that seems to be emerging. I'm just wondering if you have any thoughts on that, especially since the license has been redrafted, the 3.0 versions.
Yeah, the 3.0 version is out now. I mean, I can see the non-commercial use has always caused a lot of problems because there are various definitions of non-commercial use. Sometimes when I talk to filmmakers, for example, who use Creative Commons licenses, so the Ignacio example is actually kind of an interesting one because filmmakers often distribute their works through film festivals, and the film festivals aren't commercial fora, but if they win, they get money. And that's often how they gain recognition, and actually for a lot of these people it's their only source of income. And so the question is that a commercial use? Is that a non-commercial use? How do you rationalize that process? Just like answering the earlier question, it's a really gray area. And the thing to remember about a Creative Commons license as well is that it's a non-exclusive license. So you can license it to non-commercial uses, and you can also license it to commercial uses for certain people. So you don't actually, once you're involved in a non-commercial use, it doesn't actually mean that the creator couldn't come back and give a commercial term. Now I can see the problem with a course pack where where there's a non-commercial term and you're asking this question, is Kinko's making money off that? Is that a commercial use? My guess would be that a court would probably say no, but that's a guess again, so I really don't know.
What about in the example you used, if Ignacio won an award, let's say $100,000, is Anita, should she be getting some of that money? Because obviously that song was probably important in winning the award.
What do you think?
In a way, I would think so, and because it's being acknowledged in there.
Yeah. I mean, I think that's like copyright's all about your gut instinct, and if you think someone's done something wrong, they probably have, and if you think that they're probably doing something fine, then they haven't. I think what would happen in that situation, and it's, again, granted, it's a difficult situation to police, but Ignacio ideally would go back to Anita and say, look, I won $100,000. I think your song had a lot to do with it. Here's 5,000. Here's 10,000. Here's 100, whatever. Give her some portion. But there's absolutely no way to enforce that short of Anita knowing that he won that award. And that's one of the interesting bits about Creative Commons that I like to emphasize, is that it's about more than just attaching a license to a work. I think it's about creating a community, and it's about agreeing to a set of principles on how you're going to govern your conduct. I don't know if everybody who uses Creative Commons licenses agrees with that. They probably don't. But I like to think that getting people thinking about it that way is the right way to think about it, so then you use those principles to govern your conduct accordingly.
Bringing this to the level of educational institutions, why does Creative Commons not have a somewhat more restrictive educational use license as opposed to the non-commercial? Because a non-commercial use can, someone from Focus on the Family, which is a nonprofit in the United States, could use an image, and even though I may not agree with the politics of the political nonprofit. So why not move into that educational use only license?
Yeah, I mean, huge question with Creative Commons more generally is how many specialized licenses to create. That's one of the questions. I mean, there's huge controversy about creating Creative Commons licenses for kids. So kids, generally minors, so actually have little ability to contract under the law, but there's this question, do we create Creative Commons licenses for materials that children create in classes and for educational materials? There's a concern about proliferation of licenses. And so there's this concern that you remove, as part of the whole idea of Creative Commons was that you create a beautiful world where there's one license that does everything. And that's really simple, and when the license changes, everybody's on the same program. Version 3.0 comes out, everybody subscribes to that new version. That's the world. When you create when you create new licenses, you start fragmenting that vision. You make the situation very complicated, and there's a lot of uncertainty, it becomes a lot harder to use.
There actually was an educational Creative Commons license created. It never really took off, in part because there was a huge amount of argument kind of within the community about whether the distinctions that separate apart were actually appropriate. And it may still be kicking around on the website, but it effectively as an entity, it's more or less dead in the water.
Just to speak to that, there is a funding body in BC called BC Campus that funds technology and research. And they offer, through their SOLAR program, which is Shareable Online Learning Resources, they offer a BC Commons license, which is based on the Creative Commons license, but allows for use, it specifies use within BC higher ed institutions.
Okay.
So if you go to bccampus.ca, you can find out about that.
And but that's one of the that was another point I wanted to. It's really a question of symmetry, I think, in a weird way. How much do you want to see one license as ruling the world? So it's been, that's why Richard Stallman, the guru of the open source movement, the computer software movement, actually repudiated his association with Creative Commons, was because they were creating all these extra licenses, and I think that's why the educational licenses haven't flourished. And there's also a point as well that in the U.S., because their fair use exceptions are so much broader, educational uses are often encompassed within those, and so
But we
regardless.
don't have that in Canada necessarily.
Exactly, and so we like to think of Creative Commons as a global organization that has local, that has branches in every country. The real thing is Creative Commons was created in the U.S., and so the U.S. office drives policy.
Do you have any knowledge of or examples of pitfalls or misuse or abuse of this system by, say, corporate interests or others? What might we watch out for, or just even out of curiosity?
Yeah, I mean, the standard one is taking something that someone's licensed either for non-commercial use or even for commercial purposes, and using it without naming them, using it for one of the classics is using Creative Commons works for non-commercial purposes for for-profit events. So if you're hosting an event and you want music, you want music playing in the background, or you have a website, a marketing website, these sorts of things. I mean, they're pretty standard. It's basically people not following the license provisions. But I haven't got any sort of really creative examples off the cuff right now that I could give you. But the wiki travel one was classic. I mean, just showing up in a commercial magazine, the sort of wiki travel's entire travel log of traveling to Uruguay or whatever the page was. It was the magazine was clearly profiting, didn't attribute, completely commercial purposes.
So does the wiki own that information? Is there any action to be taken against someone infringing on common? I mean, where do they go? And who is the owner? So my understanding is the wiki is public input onto a common site. Mm-hmm. So if they took a whole page, there was lots of creators. Mm-hmm. Mm-hmm. So who would actually fight against the magazine?
Mm-hmm. Interesting. Yes. Wiki travel could itself embody the claim of its creators if it wanted to. I believe I'm not sure whether.
Was that the moderator? Is it? I mean, who is Wiki Travel?
Yeah. My guess, and I'm not 100% sure. My guess is there's probably some sort of incorporation that's happened at some stage of that entity. And they could bring a claim. Any one of the creators could bring a claim. Joint creation under copyright law entitles you to make a claim. So any one of those creators could make a claim. They could make a claim in Canada if the copyright violation happened here, and they'd have to bring it to court. So,
and then you have to show damage?
What do you mean by showing damage?
This hurt me in some way?
That they lost? No.
I mean, they posted it into a public domain, basically, in my naive eyes.
Yeah.
So how can there be damage?
Yeah, you don't actually have to show damages. The fact of the violation is enough. Damages would give you bigger damages, so if you can show that this caused you damages, that means you'll get more at the end.
I mean, so you can only argue for acknowledgement.
You can argue
If
for
that's what
you
the-
can ask for some sort of punitive damages, which would be that was bad. We're going to fine you $500 for doing that. I mean, the reality of the world is that people don't take things to court. It would probably be enough to send a letter to the magazine saying you shouldn't have done that. That's our work. We won't sue you if you give us a $1,000 donation to Wiki Travel. And the magazine probably will do that. And that's how 99% of copyright disputes get resolved. So,
You said copyright expires. Can it not be renewed?
no.
It can't at all.
Well, it can in some cases if, for example, you create a work and it's been significantly modified. for
What about
example.
if you haven't used it? I heard about people renewing their copyright on music they've written. Is that not correct?
In some instances of copyright, you have to meet certain filing requirements. So
Oh, okay.
it could be for that part of music, but generally you can't renew copyright. My guess is when they're saying they're renewing copyright, it could be U.S. based because we don't have those requirements here in Canada. I know that This Land Is My Land had that same problem. They didn't renew their copyrights, and so they lost the copyright.
Somebody else gets it,
It's
yeah.
a registration system. We don't have a registration system here in
Okay.
Canada, so it's not as relevant.
So now that the copyright term is 95 years, works that were made within the last 95 years, if they've already gone to the public domain, they can't be snatched back. They're good.
But they can be snatched, and that's a really interesting point. That's what this is what the world turning into regulated use means. So Shakespeare's public domain, but if you create a new edition of Shakespeare and you publish it, that's copyrighted. And things like broadcasting right or communications rights. So you make a movie, that movie's entered the public domain, but then you rebroadcast it on CBS or whatever. CBS will claim copyright over that rebroadcast of information. So it's actually really interesting. That's how you get copyright on things that have entered the public domain. And so you have to be really careful if you think something's in the public domain, that you're using the version that's in the public domain and you're not using the version that actually has been subsequently copyrighted because someone's republished it or repurposed it.
So if I scan a public domain work, then I have copyright over the scan.
If you've contributed a significant amount of skill, creativity, labor, and judgment, then so maybe maybe just scanning might not be enough, but if you scanned it and had to make sure that the pages were the right way, you cropped the edges of the image, something like that, you had to fiddle with the contrast.
Okay.
So splicing a movie and editing it for time is enough work.
Could be.
Okay. Another question: does copyright on a work apply to the copyright law of the time? So a 1924 work resides under copyright law from 1924,
Yes.
as opposed to. So okay, all right. Well, that's
Yeah.
good to know. No, it's actually useful to me.
One of the things I do here is we negotiate license agreements for online resources for our campus. And one of the things that we do is there are lots of examples of model licensing. And so we've created clauses that are acceptable to us on campus or even provincially or even in a Canadian context. So I'm wondering if Creative Commons has any interest in this allowing a kind of a model license that we could adapt to our particular needs here.
Yeah, no,
Again,
Creative
choosing clauses.
Creative Commons does that a fair
Maybe even some of
bit.
it.
Yeah, I mean, we're currently working with with funding agencies around the world actually on creating licenses that they can, sort of model licenses that they can use either based on Creative Commons or adapted from Creative Commons. But again, Creative Commons' interest is there's a real push-pull within the organization about creating multiple licenses. I like to think that everybody could come up with their own license, but a lot of people really are opposed to that view because they think it makes things too complex. Hard to understand.
Is there a license on a Creative Commons license?
Creative Commons is heavily trademarked in every jurisdiction.
So it's spyware.
Yes.
one last question just about open access. I don't know a lot about it, but I've heard some discussions about it. There's a couple of people on campus that are working. Do you guys work with the open access movement, which pushes to make scholarly work open and searchable to anyone?
Yeah, Creative Commons has a huge interest in that. Creative Commons and Science Commons. So that's a big part of it. I believe enough of the openly accessible journals are licensed under Creative Commons licenses.
Most of them are.
So
yeah.
So I wouldn't say all, but a good number of them are. And so yeah. But again, Creative Commons, we take a very sort of hands-off approach. So we like people adopting our licenses, but we don't force them on anyone. So if it works for you, then use it. But there's really no push to sell it to people, I think would be the way. So Creative Commons doesn't actually necessarily track who's using the licenses.
Any other questions? All right. Thank you so much.